All right, so now that we're recording, I'm going to start over. Welcome everyone to the July 11th Morning Mug. This is part of a series of efforts the Arlington Democrats are doing to make sure that our membership is well informed about an important issue on the November 3rd ballot. On November 3rd, Virginia voters are going to be considering a constitutional amendment to create a bipartisan redistricting commission that will be responsible for redrawing electoral districts in the Commonwealth. Currently, the Virginia Constitution has this power, solely the power of the legislature. So there is a current provision in the Virginia Constitution that gives the drawing of district lines the sole responsibility of the General Assembly. This proposal on the ballot, as with every constitutional amendment, has been passed through two different legislative sessions, because to have a constitutional amendment in the Commonwealth of Virginia, you must have the same bill pass both chambers of the House Virginia General Assembly with an election in between. So it has to be 2 consecutive years as long as there's election in between the two. And then the issue goes to the voters. So this particular constitutional amendment was passed in 2019 session. There was an election in 2019. It was then passed in the 2020 General Assembly session. And so now it's on the ballot for the citizens of Virginia and the voters of Virginia to decide whether or not they would like to amend the Virginia Constitution. Because this is a very important issue, and we know that there is a lot of very passionate activists within the Democratic Party, both for and against this constitutional amendment, the Arlington Democrats are making sure we have a lot of educational resources before the party decides whether or not it would like to take a position on the constitutional amendment. So at this point, the Arlington Democrats has not made a determination of what we plan to do as a party. Later this month, our steering committee is going to vote first whether or not to take a position, and then which position to take should we decide to take one. To help educate all of our members, we had a roundtable discussion. It was a very lively discussion. I encourage everyone to watch the video. I'll put the video link in the chat as well. We curated a few resources on the issue, and I'll share the link to that folder on the chat as well. And then this is part of another effort where we're having these morning mugs dedicated to the issue. Today's morning mug is going to be focused on the proponents of the amendment. So we've asked one of our grassroots activists, Chris DeRosa, to talk about why she supports the amendment and answer some questions. And then we're going to have a Q&A and then some general conversation. We're going to then have grassroots activist Craig Hines discuss his opposition to the amendment next Saturday, during the next Saturday morning mug on July 18th. And I do see that Craig is here. I'm pretty sure both morning mugs are going to have activists on both sides of this issue. The one thing I just want to remind everyone, kind of ground rules of reasonable minds can differ within our Big Tent party. So we're really here just to make sure that the people weighing in on this issue know what's on the ballot, understand the positions, both pro and con, and make sure that every person has the information they need to make the right vote. So no, we're all friends here, I guess is what I'm saying. So with that, Chris, do you want to get started?
Okay, I can do that. Hi everyone, I'm Chris DeRosa. I'm a precinct captain in Lexington precinct. Thanks for all of you for your hard work. We had a great election. Was that last week or this past week? Losing track of time. Anyway, let me see if I can share my screen. Okay, let me hide this. All right, there we go. Okay, I think that's where we are. I'll minimize this. Okay, so anyway, I am here. I'm a grassroots activist. I'm a retired special ed teacher. Been working on lots of different issues. One of the big issues I've been working on recently is on the ending gerrymandering in Virginia by bringing on a commission. So I'm here to ask you to vote yes when you see your ballot on November 3rd. And those of you who are in the general Arlington committee, I hope that you will also support it when we vote to take a position or not take a position on the sample ballot. So one thing I wanted to point out is that one thing that struck me is it doesn't matter what issue is important to you, whether it's gun violence prevention, criminal justice reform, climate control, they're all impacted by gerrymandering. And we shouldn't be fooled. It's not just the Republicans who do it, the Democrats do it too. So as Maggie said, right now the Virginia Constitution gives the power to draw maps to the General Assembly. And the only criteria that it lists is that the district shall be contiguous and compact territory. And as she explained, we have gone through 3 steps in the process of changing the Constitution. In Virginia, we don't have citizen referendums like they might have in California or Michigan. So this is the way we can enact permanent change. So the last step is November, when the voters get to decide whether to approve this constitutional amendment or not. So this is what the wording will be on your ballot when you see it in November. Question, should the Constitution of Virginia be amended to establish a redistricting commission consisting of 8 members of the General Assembly and 8 citizens of the Commonwealth that is responsible for drawing the congressional and state legislative districts that will be subsequently voted on but not changed by the General Assembly and enacted without the governor's involvement, and to give the responsibility of drawing districts to the Supreme Court of Virginia if the Redistricting Commission fails to draw districts or the General Assembly fails to enact districts by certain deadlines. As usual, it's quite wordy, but that kind of sums it up. So what will the commission look like? It will look kind of like this, but I have symbols here. Let me explain. If the constitutional amendment passes, we're going to have a redistricting commission consisting of 16 members. 8 of them represented by the black C's on the bottom row will be citizens. One of those citizens will be the chair of the commission. The other 8, shown at the top here, will be members of the General Assembly, 4 delegates and 4 senators. 2 of the delegates will be Republicans, 2 of them will be Democrats. 2 of the senators will be Republicans, and 2 of them will be Democrats. So you can see there's a balance here between the 2 political parties, and all the legislators are balanced by an equal number of citizen members. So what will happen is the leaders of the General Assembly are going to, by December 1st, appoint 8 legislators to the Redistricting Commission. So we have 4 General Assembly leaders. The Speaker of the House, House Minority Leader, President pro tempore of the Senate, and the Senate Minority Leader. Each of them will select 2 of their legislators to the commission. So you will end up with 2 Republican delegates, 2 Republican senators, 2 Democratic delegates, and 2 Democratic senators. So again, that's by December 1st. All right, then we have something called the Selection Committee. This is the committee that will be responsible for selecting the 8 citizen members of the commission. They will be, let's see. Okay, those members will be 5 retired Virginia Circuit Court justices. So first, the Supreme Court of Virginia will certify a list of qualified and available retired circuit court justices. That will be done by November 15th. So soon, less than 2 weeks after the ballot initiative. Okay. Each of the General Assembly leaders, again there's 4, will select 1 justice from that list to the Redistricting Commission Selection Committee. Those 4 justices will then select the 5th justice from that list. Okay, so now the 4 General Assembly leaders are going to submit a list of 16 citizens who are applying for the Redistricting Commission, at least 16. The Selection Committee, those 5 retired justices, will select 2 citizens from each list. So it's going to look kind of like this. Speaker of the House's list, 2 will be selected. House Minority Leader, 2 of those will be selected. And the same for the Senate President pro tempore and the Senate Minority Leader. So those are your 8 citizens. That's the commission. What else does the constitutional amendment establish? It will require that at least 3 public hearings in different parts of the state to be held. It could be more. All records and meetings shall be open to the public. That's transparency. That's very critical. In the past and in history throughout the US, maps are drawn by the General Assembly or by whoever they might hire. And that's the party in power, not necessarily the entire General Assembly. They often do that behind closed doors. We never know what they're saying or what they're doing to draw their maps. So having that transparency piece is going to be very key. The General Assembly will be voting on the maps that are presented by the commission. They can vote yes or no, but they cannot change those maps. They cannot amend them to their favor. Okay, 2 attempts must be made by the commission and the General Assembly to get fair maps drawn and approved. The constitutional amendment will also put into the Constitution protections for minorities. Every map must adhere to federal and state laws, the Voting Rights Act of 1965, the Equal Protection Clause of the 14th Amendment, and any judicial decisions that are related to redistricting or those laws. The Constitution will also state that the district shall provide opportunities for racial and ethnic communities to elect candidates of their choice. None of this is in the Constitution now in terms of what the General Assembly has to adhere to when drawing maps. So this is critical protections. It also states that maps shall not deny or abridge the right of any citizen or racial language minority group to vote and elect representatives of their choice. That's the constitutional amendment, kind of a brief summary. There is additional criteria which was passed in a bill, SB 717, and it's also HB 1255. 717 was patroned by Senator Jennifer McClellan. HB 1255 was patroned by Delegate Sia Price. Okay, so communities of interest must be preserved. Maps shall not unduly favor or disfavor any political party. That statement addresses partisan gerrymandering and is quite important. Okay, so as I said before, the Commission and the General Assembly will have 2 attempts to draw and pass new maps. The Commission requires a supermajority of at least 6 of 8 legislators and at least 6 of 8 citizen members to approve the maps, which they'll send to the General Assembly. So for the House maps, at least 3 of the 4 delegates on the Commission must approve. For the Senate maps, at least 3 of the 4 senators on the Commission must approve the maps. Okay. And true, there is a need to probably pass more criteria bills or enabling legislation. This is an example of what that bill or bills might look like. This is from SB 203, which was co-patroned by Senator Louise Lucas and Mamie Locke in the Senate. It passed both houses, but unfortunately it was killed in conference committee when they could not agree to fix the small differences in language. I think there were 5 different sections or areas where the language was slightly different. So for example, stating racial, ethnic, geographic, and gender diversity must be considered when forming the commission. Directing the Supreme Court to appoint 2 special masters to assist the court in the establishment of districts. This bill also established qualifications and reasons for recusal of both the justices and the citizen commissions. Sorry, let's see. Okay, so for example, if you are a relative or a cohabitant, I guess, of the home of an elected official, you may not apply for the commission. If you are a relative of a sitting member of the General Assembly, even if you are a Supreme Court justice, then you must recuse yourself from the decisions having to do with this. And so these are the kinds of criteria and procedures that still need to be established and can be done anytime from now to the end of the year. So it's kind of the summary. I ask you again that to vote yes on the constitutional amendment. There are 4 key reasons, in my opinion, that this is a very good constitutional amendment. It's going to change the way that maps are drawn. It's not perfect, I grant you that, but it will take us giant steps toward drawing fair maps in Virginia, maps that will give us, the voters, the chance to let our voices be heard. Voters should choose their politicians, not the other way around. Vote yes, because for the first time, citizens like you and me will have a place at the table. Vote yes, because for the first time, transparency will be required. Vote yes, because protections for minorities will be written into the Constitution. Vote yes, because these will be permanent changes that cannot be changed easily by a simple vote in the legislature. And I'm not the only person saying vote yes. We have a lot of people. Some of these names you may know. Senator Tim Kaine and Congressman Don Beyer have come out repeatedly in favor of this constitutional amendment. A lot of people talk about the House votes, but keep in mind in the state Senate, the 38 out of the 50 of them passed this constitutional amendment. Senate Black Caucus, the entire caucus supported it. The League of Women Voters, Common Cause, Princeton Gerrymandering Project, ACLU, Eric Holder, Brennan Center for Justice, League of Conservation Voters represent us. These are some of the known names, local, state, and national. Okay, here's some other names. We even have 7 professors from the Virginia colleges and universities wrote a piece. Katie Fahey, she's a grassroots activist who started Voters Not Politicians in Michigan. David Daley, if you have not read his book about gerrymandering and other voter suppression tactics, please get his book. And Justin Levitt. And editorials, there have been many editorials written. Every major newspaper in Virginia and beyond have written in support. That includes the Washington Post and the New York Times. So on November 3rd, voters will vote yes or no on the Constitution. It's in their or your hands. And in August, if you are a member of the Arlington Democratic Committee, you will have a voice in that as well. Okay. I think that's it.
All right, thank you, Chris. So before getting to the direct questions for you, Chris, want to acknowledge some resources and conversation that's been happening in the chat. So thank you all for your high knowledge already on this issue. There's a lot of resources that have been shared on the chat. Right now, one of the conversations is the constitutional amendment would, if the commission fails to reach agreement on the district maps, it would go to the Virginia Supreme Court. And the question is what standard the Virginia Supreme Court would apply to draw the maps, should it be sent to the Supreme Court. So, Chris, I don't know if you have a comment to that or if we want to hold that until the general conversation later.
Well, I know the Supreme Court, like in most courts, have to abide by certain ethical standards. So that will always be in play. They will have to, if they draw the maps, and no Supreme Court has ever drawn the maps themselves. They've always hired special masters, experts in that field to draw the maps. Those maps have to abide by whatever's in the Constitution. So they have to give fair representation to ethnic and racial minorities, for example. They have to have open hearings. They have to have everything that's transparent. So that is one thing. And then you can pass the legislation to make sure that the Supreme Court will appoint special masters.
Okay, thank you. Well, so I have one question that I'm going to be asking both grassroots activists. So one of the constitutional requirements federally for redrawing districts is to make sure the districts are compact, contiguous, and represent communities of common interest. So with this commission, how does your position of supporting the commission best achieve the goal to make sure that the districts are compact, contiguous, and I guess most importantly, represents communities of common interest?
Okay. Well, the Constitution already requires that the maps or the districts are compact and contiguous. So that will not change. Communities of common interest or communities of interest are in SB 717, that is now law, that was passed. More importantly, I think this constitutional amendment will put in the Constitution protecting the rights of racial, ethnic, and language minority groups when drawing maps. That is not there now. So there's nothing to protect any of us who might be in one of those groups and want our voices heard. And that's one of the reasons why we had the Supreme Court ruling, Bethune-Hill, which said, yes, we did have quite a few districts that were racially hacked and cracked to dilute the vote of the African-American voters in Virginia. And that was changed because of that. I think it's important because we're going to have citizens on the commission. It's not going to just be politicians drawing these maps. And probably even more so, I think transparency. We can testify at these meetings. They have to have at least 3. Hopefully they'll have more. We can watch what they're doing. We can listen to them as they meet. And we can keep an eye on them to make sure that the right criteria is being followed when they're drawing the districts. Hope that makes sense.
Absolutely. And then I have one question for you, because this is a common concern we hear from people that oppose the amendment. And that is that the Virginia Supreme Court justices are appointed to 12-year terms by a majority of both chambers of the General Assembly. With the legislature selecting the judiciary, would there be an incentive for a political party that has appointed the most justices to not agree with a plan to have the court draw the lines?
Well, you'll have to ask Republicans that. But our belief is that it would be in their best interest, the Republicans, for example, or the Democrats, to make sure that the maps are drawn that really meets their needs and addresses their desires and their voters' desires. Keep in mind that I think all except one of the Supreme Court justices were approved by 100% of the General Assembly members. So even though most, I think 10 of 12 were appointed by Republican governors, 2 were not, but those 10 were approved by just about everybody in the General Assembly. So if they were truly partisan hacks and were not qualified through years and years of service and moving up through the courts, then they would not have been approved. Let's see. And again, I referred earlier to judicial ethics. They need to do that. And recently the Supreme Court sided with progressive suits that were filed. For example, the Supreme Court of Virginia upheld the governor's right to ban guns on state capitol grounds. They upheld the governor's right to impose restrictions during the pandemic. And I believe they also upheld his right, or the right to impose a moratorium on evictions through at least the end of June. I'm not sure what the status is now. So they are not necessarily partisan hacks.
Yeah, thank you. So with that, and thank you very much, Chris. I know you've been working on this issue for a long time, and we appreciate hearing from you. To the broader group here for the Morning Mug, I know we've been having a robust conversation in the chat. Are there any, comments or questions that those of you on the call have?
I haven't been following the chat, so I have no idea.
Well, in the chat, we've shared a lot of resources about the special master, the commission. There's been some questions about what a community of interest means, which that's a good tidbit we might want to have kind of a general conversation about. So this is kind of open to everyone. So communities of common interest is not well defined in the law, because you can make a lot of arguments of, is a community of common interest, say, a certain ethnic group? Is it a certain racial group? Or, as we've been seeing with the most recent cases, is it political identification? For instance, the Supreme Court of the United States upheld political gerrymandering, I believe in 2019. So, thank you, Julia. So SB 717 says that a community of interest means a neighborhood or any geographically defined group of people living in an area who share similar social, cultural, and economic interests, and does not include community based upon political affiliation or relationship with a political party.
Yep.
So.
One of the areas that this is interesting in, I think in Virginia, I can't remember which campuses, but it's happened elsewhere as well. Sometimes college campuses can be a community of interest. And we have seen where they have drawn lines right through the middle of campus. So you're dividing the students and maybe staff and faculty who live in the neighborhood to kind of come together as a voice to support a candidate or a position of interest to them. And their polling places have even been taken off campus. So those people might want to form themselves as a community of interest and testify to that fact in front of the commission.
All right, and because I did get the question in the chat, if anyone would like to make a comment or have a question, please just use the raise hand feature in the chat, and then we'll make sure we have kind of a moderated conversation. All right, so continuing the text chat, because that seems to be where all of the action's happening today. There is, oh, I've got hands up. All right, so first up, Bob. What is your comment or question?
I think the entire debate over whether to approve or disapprove of the constitutional amendment turns on to what extent it can be cured by Virginia-based legislation. It's not clear to me, and I'd love to hear other people talk about this, the extent to which an action of the state legislature really can bind the Supreme Court in terms of what tests it applies and its methodology and so on. And it's not clear to me how the Supreme Court action will be judged. If the Supreme Court action is inconsistent with the constitutional law, case law developed by the US Supreme Court, I could see how there could be appeals taken to the US Supreme Court. My general worry about getting into that whole thing is that if there is a lot of opportunity for litigation of what's happening at the Virginia Supreme Court level, it might be 5 years before redistricting takes effect for the 2020 census. We saw this already in states like Texas and so on, where congressional redistricting happened halfway through the decade. So I would really love to hear people talk about what happens at the Virginia Supreme Court, how it is bounded by judicial review, how it is bounded by the legislature. I just really need to understand whether it's sort of a black box or it's a nuclear reactor. Thank you.
So, Bob, let me make sure I understand your question. Your question is, since the Virginia Supreme Court may have a role in the creation of the maps, you're unsure if they would be able to hear cases to review the constitutionality of the maps?
No, I think that the Virginia Supreme Court will make a decision, okay? And hopefully they make the decision in 2021 or 1 year, after. But if in fact people can contest whether what they did was in accordance with whatever standard they're supposed to meet, and I assume the burden of proof would be on the people contesting what the Virginia Supreme Court does, whether as that litigation goes to the federal court system, and I don't know how heavy a burden would be on the people taking it to the federal court system. how likely is it that this whole thing will be litigated for 5 years in the federal courts without
Okay.
the thing taken?
So the one thing I want to differentiate is you're not talking litigating the amendment. You're talking about litigating the maps. That is currently the process. So regardless of how the amendment happens, any concern about the maps being proper with the law is a litigation solution. So like currently, as Chris was mentioning, the racial gerrymandering case here in Virginia did take a good, I think, 7 years to work its way through the courts. So I guess my question, please chime in other people if you have different views. I don't think that is a difference regardless of whether or not we enact the amendment.
That's absolutely right, as I understand it. I mean, we already were mired in litigation for years, doing it the old-fashioned way. So it's hard in a litigious society. It's almost impossible to rule that out.
I can add that in terms of like if it were to go to the Supreme Court and they were to draw a map, they have to follow all federal law. And if they were, for example, did not follow the Equal Protection Clause or the Federal Voting Rights Act, then you could challenge that in federal court and say, argue that the map they drew was not proper. But I think it's worth taking into account that there's nobody says that this map has to go to the Virginia Supreme Court. That's just that's the fail-safe that is created by this amendment. It's actually the current process. If the legislature can't draw a map, it goes to the Virginia Supreme Court. And if it is true, which I think it is, that the Virginia Supreme Court would appoint a special master that draws fair lines, there's no incentive by anyone to kind of nuke the system and send it to the Virginia Supreme Court, because they know it's going to be a fair map either way. So they might as well be involved in the process of drawing the lines the way they kind of feel it should be.
Okay. Thank you, Annika. So Carol Cochran, you had your hand raised. I don't know if you have a comment or question.
Yes. Can you hear me?
Yes.
Good. All right. Well, I still wasn't convinced that when you have 10 out of the 12 who are Republicans, that they will act in good faith. And so the last speaker sort of mollified me somewhat, because it sounds as though that they still would have to get a special master if it did go to the Supreme Court.
They probably will. No Supreme Court that I know of has ever seen the justices take off their robes or keep them on, sit down together and draw maps. Anytime that's happened, they've hired a special master. That's generally the way it's done. Okay, no Supreme Court who has been given that responsibility has ever gerrymandered maps. On the other hand, legislators always gerrymandered their maps. It doesn't matter if you're a Republican or a Democrat. And both parties in Virginia did that in 2011, 10 years ago. So what we're trying to do is bring a balance, make it fair, make sure the voters get their voices heard, and that they have a fair chance of electing representatives and senators that they want to.
I guess what I'm thinking of is lately there are so many people who don't act in good faith, and in the past it's been done because they had a sense of honor, but I don't believe that's the case anymore. So that's what I'm worried about. And so that it possibly, well, we've left the door open for some shenanigans. So please put my mind at rest.
Okay, well, again, as mentioned earlier, 3 recent cases, the Supreme Court supported the governor and it allowed him to have the power to make certain executive orders regarding guns on the Capitol grounds, restrictions during the pandemic, placing a moratorium on evictions during the pandemic. So I don't think we have seen at the state level what maybe we have seen at the federal level. And no matter who draws the maps, if people are not happy, like if right now the commission would make sure Democrats and Republicans on the commission and in the General Assembly will all have a voice in this, not just the group in power or a few people in power. But if they were unhappy, no matter who's drawing the maps, you're going to see suits filed, and it's taxpayers' money that's going to pay for all the litigation that's going to go through the courts. So let's do it the right way.
I think also it's worth differentiating between like ideology and partisanship. I think it's true, especially at the federal level, you've seen the courts get more ideological, as in more conservative ideology. But in terms of partisanship, as in blatantly supporting one party over the other, you can see in the Supreme Court just yesterday, they actually, the justices that Trump himself appointed said that he can't argue that no one has a right to get his tax returns. So I don't think you've seen really courts, specific, like clearly and obviously support one political party over another. It's more supporting their ideological views. And in the past, as Chris mentioned, there's been a lot of courts that have had to draw maps, and not a single one of them has gone and supported the party that appointed them and drawn a political gerrymander.
Okay, thanks, Ankit. I see you had your hand raised. Did you have another point, or was that an old hand?
I'll just let other people go for now.
Okay, thanks. So Marjorie, you had your hand up. Marjorie Hobart.
I think we need to remember that unlike the federal Supreme Court, the Virginia Supreme Court serves terms. And if they have an interest in being reappointed at the end of their terms, they have to be, have served in an even-handed way the interests of the entire populace of Virginia. And I don't think you have quite the freedom that lifetime appointments gives to justices in the federal Supreme Court. I've been active in Virginia politics for a very long time, and I can promise you that when the Democrats controlled the General Assembly much earlier, they were just as brazen in the gerrymandering that they did in state legislative districts and the federal districts. Our hands have not been clean. And I think that the value of this plan, even I admit it's not the plan that the original advocates went in with and would have preferred. Nonetheless, it is a plan that allows for all sides to have an opportunity to be heard and then to participate and to see how the decisions are made. And I think it is of high interest to the first people being appointed to this commission to be successful. I don't think that they are going to take roles on this commission thinking I'm going to really ruin this process and send it to the Supreme Court and go yan yan and yan yan at the end. I think they are all going to be people who are going to be wanting this to be a successful process and to show that we can have an open and fair process that adheres to standards. We've had compact and contiguous in the state constitution for decades, and you still had a district that had half of it on one end of the Bay Bridge Tunnel and half on the other, or a few precincts on the other. And you have our own senator's district that goes from Loudoun County down through southern Arlington. Right. Those are not contiguous districts. So we need to have broader attention to these decisions instead of just General Assembly members behind closed doors.
Thanks, Marjorie. So the next person at their hand up was Julia Tanner. And Julia, I know you've been also very active on this issue. So I don't know if you have a comment or a question.
Thanks. I just have a few comments. I agree with Chris and with Marge Hobart. I think that there are two other aspects to the value of this of the constitutional amendment that I think I want to bring out, which is one, a citizen chair. So this is going to be a citizen-led commission, and I think that's one of the really great achievements of this amendment, is bringing citizens into more control of the process and giving us a seat at the table where we don't have one now. Right now, it's just the General Assembly gerrymanders, and this will bring citizens of the Commonwealth in to be able to rein in those districts. Secondly, I'm a lawyer, And I think something that gets a little discounted is legal ethics, because it's just such a joke, right? Everyone's like, oh my God, lawyers, they have no ethics. But actually, lawyers do have ethics. We're trained, we have to pass a bar exam, and we can be disbarred for violating our legal ethics canons. Judicial ethics are even more serious. The justices have to follow these canons of judicial ethics, and we can see that in action where they're applying the rule of law in those cases that Chris was citing, where they upheld Governor Northam's bar on firearms in Capitol Square during the gun rights rally. If they were really strong knee-jerk Republicans, they would have been like, oh my gosh, Second Amendment rights. How can we uphold a ban? But they're not doing that, because this is where the rule of law led them. This is an emergency, it's public safety, the governor has this authority, they upheld him. And it was the same in his ban on masks for aspects of his COVID-19 guidelines. They upheld that because he has the law on his side. So I believe that the Supreme Court, these justices take their role responsibly, they take their judicial ethics responsibly. I don't think they're gonna act like partisan hacks and gerrymander the heck out of the map for Republicans. I think they're gonna appoint a special master, and they're just going to let the special master do their work. Special masters are generally citizens. They try and follow principles of nonpartisanship, but seeing where communities of interest take you. And in the Golden Bethune-Hill case, that brought 4 more Democratic seat flips. And one of them went to a new African-American delegate seat in the House of Delegates for Virginia, because Virginia is turning blue. So if you get fair redistricting by a special master, that is likely what you're going to see. So when the Supreme Court gets the drawing of the maps, if this commission deadlocks, I don't think we have reason to fear. That's my personal view. I think we let the process play out, and I think it will go fine.
Julia. So next in the queue is Lillian Clementi. And Lillian, I believe you also are very active in this issue here in Arlington.
Yes, I've worked with One Virginia for a couple of years now, pretty intensively. I really agonized over the SCOVA provision and thought hard, do I stay with this or do I walk away? And I've thought repeatedly about it. And what it boils down to, I knocked on 400 doors for Hillary Clinton in 2016. I knocked on 275 doors for Ralph Northam, in part because I wanted him to be overseeing redistricting in 2021 and not Ed Gillespie, who'd been an architect of Red Map, basically. I think it would be easier to deal with this issue if at the national level, one of the parties hadn't made basically raised obstructionism to the level of an art form. So I really understand the concerns about this. What I have come to after agonizing over this a lot is that nobody can predict the future, but we have pretty good data on the past. We know that both parties gerrymandered in 2011. When the governor called the special session in 2018, both parties came in with gerrymandered maps. In 2019, One Virginia went into the Senate, Democratic-controlled Senate, with a beautiful pate, came out with something that has some sausage in it, but has been endorsed by a number of national groups, including Eric Holder, Don Beyer likes it, Tim Kaine likes it, et cetera, et cetera. I don't need to repeat all that to you. What I watched live as our anti-gerrymandering amendment was defeated by Democrats in the Senate. And it's very frustrating to me to have Mark Levine say, you don't even have a gerrymandering provision in there. And I say, right, it was defeated by Democrats in the Senate. I had this conversation with him in October and he said, just give us a majority and we'll come in with something really good and it'll be just like you had before. And I said, but it was the Democrats in the Senate that defeated the gerrymandering provision. And his face fell and he said, oh, well, there's really not a lot I can do about that. And even this session, at the very last minute, Marcus Simon came in with a plan that had been cooked up overnight and it leaned Democrat. I mean, so on the one hand, I'm looking at an established pattern of gerrymandering by both parties versus a history of courts that have never done this. So nobody can predict the future, but that data really looks pretty convincing to me. The other thing is, bearing in mind that there are going to be politicians on this commission. That's not what I want, but that is what we can get through the legislature, as we saw in 2019 and 2020. That if there are politicians on this thing, they are going to want to keep control of it. If they punt to the Supreme Court, then the SCOVA is very likely to appoint a special master, and they are likely to get fairer maps the way they would in Bethune-Hill. And nobody was really happy with those. There were people unhappy with the Bethune-Hill maps on both sides. So, you know, I'm putting my trust in the self-interest of the politicians on the commission, which I believe to be very finely honed. And that's what I have to say for the moment. Thank you for letting me have an opportunity to speak.
Thank you, Lillian. So I did get a question from the chat for the group, wondering about how eliminating gerrymandering is good for everyone, particularly in regards to the treatment of minorities and people that are traditionally underrepresented. So I don't know if anyone, Chris or someone, wants to make a comment about that and how eliminating gerrymandering and passing the constitutional amendment would affect the treatment of minorities in the Commonwealth.
Julia, you want to take it?
I'd be glad to.
Yeah.
There are so many ways. I mean, first of all, as Chris so carefully laid out, the amendment does provide that any lines must be drawn in compliance with respecting all legal decisions and laws, both at the federal and at the state level, that address racial and ethnic fairness. So instantly that means, as Ankit said, that the Equal Protection Clause of the 14th Amendment and the Voting Rights Act and all other laws that require that racial gerrymandering not occur, those are suddenly a state constitutional mandate for us. And in Virginia, as in all other states, the Constitution is the bedrock of our laws. So that's super important and excellent. If you do not have gerrymandering, what's going to happen in Virginia is very good because that means communities of interest are going to be preserved. Sort of the aspirational goal of not having gerrymandering is that you can allow communities of interest to vote together to elect the representative of their choice. The opposite is when you break them up, and that's when you have voter suppression because their votes don't count as much. And so what's being done here, the combination of the amendment itself plus the criteria bill which passed give us a super package which is going to ensure that communities of interest are protected. And in fact, the Princeton Gerrymandering Project has a tool in place, as do others, that citizens can use to identify their communities of interest in Virginia. So this work is already starting, and that's going to be super helpful for minority groups and the organizations that represent them, and ensuring that their voices are heard even better than before as they go to elect representatives to our state General Assembly, and also because the state General Assembly draws the federal lines when we go to elect our members of Congress.
I can also speak a little bit to this. So I'm the chair of the Arlington Young Democrats Civil Rights and Liberties Committee. So, I mean, this is obviously an issue that is very important to me, although I'm speaking in my personal capacity, I should say. And more, you know, personally, I'm an Indian American, and I think, as many of you know, we didn't have a single Indian American elected to the General Assembly until last year. That's like, what, 300 plus years of this General Assembly, not a single Indian American until last year. So it's an issue that's important to me personally. And right now, Virginians of color are protected by the Federal Voting Rights Act. But the Supreme Court of the United States has shown a lot of hostility to that law. They already struck down parts of it. And there's no, you know, it's very possible that they entirely strike down the Federal Voting Rights Act within the next couple of years. And if that happens, Virginians of colors would have no protections under current law to protect their rights under for redistricting. And what this amendment does is it basically kind of creates a mini Voting Rights Act in the state constitution. It states that no all districts, or I'm blank. I can't tell you the exact language. Basically, it's saying that all Virginians of color must have the ability to elect candidates of their choice when practicable. So that is completely separate from the Voting Rights Act. So the Voting Rights Act is struck down tomorrow, like the day after this amendment passes. That is still in the state constitution, and that can't be changed. And I think that is a huge victory for Virginians of color, because it ensures that no matter what happens at the federal level, no matter what happens in the legislature, we will always be protected and will always have the opportunity to elect candidates of our choice.
Let me introduce two terms, packing and cracking, which most of you probably have heard of. And it refers back to what Julia and Ankit were talking about, and also the Bethune-Hill case. So you can take what gerrymandered maps look like is you might take a whole bunch of, let's say, African-American voters, pack them into one or two districts. So yeah, they get to vote and get represented by one or two. But then in all the surrounding districts, their voices are not there because they were not allowed to be in that district. On the other hand, you could crack them. You split them up so widely dispersed among several different districts that they have no option, no opportunity to vote for someone that would truly represent their interests. So with this constitutional amendment, they're saying that you cannot abridge the rights of any citizen, racial, language minority group to participate in the political process and elect representatives of their choice. As Ankit has pointed out, that's important to get that into the Constitution to protect all voters.
Thanks, Chris. So next, Craig, you had your hand up. And for those that don't know, Craig is actually going to be our speaker next week in opposition to the amendment. So, Craig?
First of all, I absolutely do not like being in opposition to so many people who are such great Democrats. But the question I have is, and I'll make it next week, but I just want, as we have so many proponents on, am I correct that no person will get to this commission without being a member of the General Assembly or having been recommended by the General Assembly? There is no outside person. You're not, you know, if a delegate or senator did not recommend you to be on the commission, or if you are not a delegate or a senator, you are not on the commission. Is that correct?
Well, we would need to pass enabling legislation to make that clear.
No. As it stands now, as what we will be voting on November 3rd. I didn't think so.
If I wanted to be in that
Thank
commission,
you.
I could contact someone and say, I'd like to apply to be on the commission.
Of course.
I don't know whether I'd be selected.
It's not what you asked.
That's not the question.
Yes,
the question
okay.
is, unless you were recommended by Adam
You have to be
or
on their
Alfonso,
recommended list.
you have to be on the list drawn up by, voila, a General Assembly member, or be one of the General Assembly members who is appointed. So this is in no way independent. If the word independent should float through, that should be a red flag.
We have said bipartisan, balanced commission.
What about nonpartisan? Nonpartisan, by the way, is the word that the Arlington Arlington County Democrats resolution calls for. It calls for nonpartisan. This is totally partisan.
Right, but Craig, the committee has not taken a position on this amendment yet. That's
No. But in January 19th, as the legislature, General
Yes.
Assembly was beginning to vote.
The party did
Yes.
support an independent, nonpartisan commission, but that
Neither
the
one
party-
of which is this.
Well, that was not, we tried. In 2019, we tried to get that through the General Assembly, and it did not move forward.
Right,
So-
all
Right.
that means is that the resolution is in opposite.
Yes. Well,
We
but
can still stand by that resolution. Ideally, yes, we would like to have a truly independent commission solely of citizens.
this
And if
is
you wanted
this
to,
is
we can
zero
work-
independent.
The problem here is that Virginia has the hard road through the legislature. We can't change our redistricting process under our Constitution without going through the very people who have the most interest in keeping the status quo. So your choice is a commission that meets in broad daylight with some lawmakers and some people initially suggested by lawmakers, sure, or the smoke-filled room in the back, the old-fashioned way, the way it's always been done, and we can see where that's gotten us. And if you think 2011 was ugly, just wait. Because people have said to me, oh, Lillian, this has been going on since the beginning of the Republic. Elbridge Gerry was a founding father. Patrick Henry tried to gerrymander James Madison out of his seat in the Congress. All true. What has really put this on steroids is big data and geospatial mapping. And the technology has only gotten more powerful since the red map disaster in 2011.
So we're going to nail into the Constitution of Virginia, along with the Marshall-Newman Amendment, a half a loaf. I mean, I think we have to remember what Eileen said as this was going through. You have to be very careful about what you put in the Constitution, and this is, to my mind, obviously, simply does not pass muster to put it, because it is so hard. The reason I mentioned Marshall Newman, it's so hard to get something out of the Constitution. You know, 4 years ago, Republicans were trying to put right to work in the Constitution. That's how they think about the Constitution. It's put in there, to pardon the expression, to screw the Democrats.
Understood.
Thanks, Greg. And we're definitely going to continue more on kind of your position, and where there's a number of other Arlington Democrats that share concerns about the amendments. That's going to be next week's morning mug. So
thank you.
I encourage everyone to come back.
I'd appreciate the questions, because I like to hear the answers from the the proponents of these hard questions. That's definitely where the rubber meets the road.
Yeah. So there was another question in the chat, and that was really a concern about whether the Federal Voting Rights Act and its future with the current Supreme Court might impact the Commonwealth of Virginia, and how this constitutional amendment plays into that. I believe Ankit talked a little bit about this earlier, but I don't know if there was anything more on concerns or how this proposed amendment would fit into the Federal Voting Rights Act and any potential threats against it.
Yeah, I'll just echo kind of what I said before, which is that if the Federal Voting Rights Act were to fall or be like significantly defanged in the next couple of years under this constitutional amendment, Virginians of color would still be protected because it has those protections independent of the Voting Rights Act put into the state constitution. So it really is it really is, I think, important to do that given the makeup of the courts and the Supreme Court right now.
Thanks. And then Patricia McGrady, do you have a question?
Muted. Hi, I was a
Oh, your sound went out.
Oh, there.
There we go.
Yeah.
Okay, good. I was a long-term Arlington resident and Democrat until I moved to Green Spring Retirement Community about 3.5 years ago. Almost as soon as I got here, I got involved with Brian Cannon in 2021. And I ended up being the representative of them here at Green Spring. And I had a big thing outside my door, a big poster outside my door saying 2021. But then last November, here in Fairfax, the League of Women Voters had a big meeting on redistricting, and at least 6 or 7 or 8 or 9 legislators got up and spoke. All of them spoke in defense of the amendment, except Mark Levine. And what he said shook me right to the core. And that's why I am absolutely uncertain of how I'm going to vote. Because some of the things that he said and Craig just said about the permanence of putting in a flawed document when I was involved in it before they had come up with the wording. And when the compromise, quote, compromise came out of the group, it had not all citizens decided by an independent thing, but half legislators, and then, as Craig said, the other half chosen by legislators. So when Mark pointed all that out and that we would be putting it in concrete by putting it into the Constitution, I am really on the horns of a dilemma, and I am looking forward to next week when you talk about those problems.
Thanks, Patricia.
And
I think also, if you can keep in mind, if we do not pass this constitutional amendment, we will leave it as is. It's in the hands of the General Assembly. And so, you know, they will, and there will be no protections for minority, ethnic, or racial minority groups in the Constitution. You won't have the protections of the Voting Rights Act, judicial decisions. You will not have transparency. So going forward, you know, you can pass another constitutional amendment later if you want to make it better, and I hope we do. But that will be too late to draw the maps in 2021. And then we're stuck for another decade.
Well, if I can respond, Mark Levine's response to that is do it by legislation. He's not saying that the opposite of the amendment is nothing. He's saying that it should be done with legislation. And that is what I would think too.
You could, but legislation could be overturned the next session. Let's say if, you know, and then nothing in the Constitution says you can't draw the maps again in, say, 2014 or 2024 rather.
Yep.
So, you know, with the ebb and flow of political power, we are going to be left in their hands. And some of the bills, such as Mark Levine's, if his commission did not, and the General Assembly Commission didn't come up with maps or CIA prices, the decision would go back to the General Assembly. So once again, you are putting power back in the hands of the politicians. So that's something to keep in mind too.
This is an area where I would just like to better understand, because I've heard that legislation argument as well. So if we pass the legislation that said no gerrymandering, it would for sure apply for this upcoming session's map drawing exercise. Is that correct? I'm going to take it in steps. I'm trying to understand what could happen. So is that little part correct?
Yes.
It could, because of the delay of the census. It may.
I think Dela said in the chat that she wanted to address this point. She might be able to have an answer.
yeah.
Yeah, Jill, we can take your questions point by point for sure. I just would like a chance to respond about the idea of a purely statutory fix through a bill passed in 2021 as opposed to what the amendment offers. But we can definitely answer your questions first.
Well, I guess I just would want to understand, if we pass legislation, would it apply to the map drawing exercise we're about to enter? For sure. And then I guess I hadn't really thought about, so if we lose the House, if we lose the General Assembly, which by God, we will fight hard to not have happen, they can just redraw the maps without waiting for the census?
Yeah, they've done that before. And if I can just interject one other thing, sorry, Jill, but just going to your point, it sounds great. Oh, let's just have a legislative solution. Let's just pass a law. That'll be quick. But last session, when they tried to pass a law, the primary law that they got behind said if the commission deadlocked, the General Assembly could draw the maps. And that's gerrymandering, and that's the exact situation we're trying to prevent. And this was at the very end of the law. Most people didn't read it. They were like, oh, it's a legislative solution, hooray, hooray, hooray. But it would let the legislature gerrymander. So I would say beware of what you wish for. If you look at a legislative solution as a solution, we have to remember that our own guys who we love dearly can get really tempted to do something that might not make them the better people. We're the citizens. We have to keep them on the higher road because this is what our party is about. You know, you guys, with the Golden Bethune Hill decision, You got a fair redistricting, Democrats picked up seats. That's what will happen if the amendment gets passed. If you have a legislative solution, it's like a train wreck. Things can go wrong with that law. They can put in provisions for Jane, and that's what they tried to do. So that's my caution.
I wanted to go back. Dayla, I think you had a comment, or we're going to respond.
Yeah, thank you. So the point I wanted to make here is that drawing an equivalency between a legislative fix and an amendment is falsely valuing them to be equal, because it is the Constitution that explicitly gives the power of the General Assembly to draw the maps. So any commission that would be established just through a bill alone means that they're an advisory commission that can only suggest maps to the General Assembly. We've had advisory commissions in the past in Virginia, and their maps have not been implemented. And so, there's been this talk of vote no for the amendment, and you can get this other really shiny commission established via bill. And I understand why it's tempting to want to have a commission that is purely made up of citizens, but if ultimately their maps aren't being implemented by the General Assembly because there's no requirement that their maps are going to be implemented, that really isn't a step that far from the status quo. And the points being made about the amendment being a sort of half loaf, I think, is really not doing justice to the provisions that will be included in the Constitution for the first time, like protections for communities of color that exist nowhere else in the amendment, alongside ensuring that citizens will be at the table, ensuring that it'll be a transparent process. And to the point made earlier about this idea of mid-decade redistricting, if you have a purely legislative fix, that that commission, if there's a switch in power or something like that, that bill can essentially be ruled over, and say in 2024 or down the road, you see that switch in power and there's been no commission put into the amendment or into the Constitution itself, then there can be mid-decade redistricting. And in fact, we've seen attempts at mid-decade redistricting, and typically these are the most nefarious attempts to gerrymander and get away with it during a change in power. So I just want to bring up the point too, that by mandating the establishment of a commission through the Constitution, then we can be sure that there isn't any sort of sneaky mid-decade redistricting attempts.
Can I just add one thing onto that, to respond to Patricia? I used to be very happy that Mark Levine was representing me, and I got a constituent letter from him at the end of November that said, oh my God, we have to oppose this amendment because there's going to be a red wave and there could be mid-decade redistricting. He's never used that argument again because I think he realized it was against his position instead of for it. The Constitution is silent. It says you must redistrict in years ending in 1, but it's silent about redistricting in years in between. 2013, Obama's second inauguration, an African-American senator comes up to Washington for the festivities. That puts the Democrats down by 1, and Tommy Norment tried to push through new districts. If it had not been for a principled Speaker of the House, he might have gotten away with it. This would prevent that. And I mean, it was classic Levine, like lots of red letters, and there's going to be a red wave, there'll be a mid-district. He's never mentioned that again because he realized he was wrong.
Let's just remember, not only is Mark Levine opposed to it, Rip Sullivan voted against it, Alfonso voted against it, Patrick voted against it, and the entire, I believe almost all of the House, a Black Caucus voted against it. So this is a divisive question. But you go back to, this is going into the Constitution. It is not easy to change the Virginia Constitution.
Right.
Thank you.
And keep in mind that all 3 senators from Arlington, Favola, Howell, and Eben voted for this constitutional amendment and still support it.
As did the Senate Black Caucus.
Yeah. And I think that just highlights that there are reasonable minds differ on this particular point. And this is a very active debate within the party. I did want to, looking through hands raised, Lou, you have your hand raised and I don't think we've heard from you yet. So did you have a comment or question?
Yeah, I wanted to hear more about why it's a good thing to give special treatment to minorities. Isn't that a form of gerrymandering if we do that?
We're not giving them special treatment. We want them to be treated fairly so that they have a real vote. They have a chance to elect representatives and senators of their choice. It's not giving them special treatment. It's making it fair.
I don't know why that is required in the amendment.
You don't know why it's required?
Yeah, I don't understand what, if we eliminate gerrymandering, isn't that fair to everybody? Why would they need something special in the Constitution that says we're being fair to them? I don't know what being fair to them means.
Julia,
Community of interests.
I see your hand raised.
So Virginia, like other states, certain other states, has a large number of areas of our state that historically discriminated against minorities and did what are known as packing and cracking, especially of communities that have a large percentage of people of color. They've been subject to a lot of historic discrimination in our state. And while we might think, oh, it's modern Virginia, that's not happening anymore, we do see it happening. And the racial gerrymander that had to be undone in the Bethune-Hill case is an example of that, where they are packed into districts, which essentially dilutes the number of people that they can elect by shoving all minorities into a small number of districts, as opposed to having them the majority of their region, if they happen to be a majority in that region, which they are in some parts of Virginia. And so therefore, putting a special caution into the Constitution, while it shouldn't be necessary, unfortunately in our state, history has just shown that it is necessary. There's a lot of prejudice still in the state, and therefore it's a safeguard. It's not giving them special treatment because everyone does deserve and should get the same rights. It's more like and hey, don't forget, do not discriminate.
Yeah, and I would like to also mention, I think this came up earlier in the chat of resources, the 538 Gerrymandering Project series. So that was a podcast that went over a number of gerrymandering issues. I believe they had an episode specifically on racial gerrymandering and goes over kind of the history there and why that is a particular concern nationwide. It's not just in Virginia, but that is a key element when discussing gerrymandering throughout the country. So okay. I see a couple more hands. So let me just make sure if there is someone that hasn't spoken yet that had a comment. Let's see it. So next, Bob, did you have another comment?
We've talked about the Voting Rights Act and equal protection and the 14th Amendment. I just thought we should all reflect, and it's a real challenge when you draft language, including the language in this amendment, that both Plessy versus Ferguson and Brown versus Board of Education were decided under the same 14th Amendment. I think if you read carefully, a lot of the jurisprudence that's coming out under these Trump-appointed judges, not only at the Supreme Court, but down at the district court level, they are reading these ideas of equal protection the exact opposite way that perhaps came up under the Warren Court and so on. So I could see how a judicial review process of any redistricting could be interpreted under this new crop of judges exactly the opposite way that you're assuming it will be. And I think that there is a real fundamental question we should ask, and perhaps it goes to the design of the commission and so on, as to what extent this is ultimately a political question, and we have to rely on the the broad-based coalition support of people who want to see fair redistricting versus people who want to come up with a scheme that will rely upon future judicial interpretations of community of interest and the case law under cracking and packing and so on, because that case law will change under the Trump judges. Thank you.
Thank you, Bob. I think I understand your concern of the composition of the Supreme Court might shift. You're muted.
Of all the judiciary, there are a lot of district court judges. Trump has appointed hundreds of district court judges. And this is, the Federalist Society is redoing the ideology of the judiciary. And so just because you think that equal protection means X, it could be that when you read case laws for the next 10 years, equal protection will mean not X. That's all I'm saying. But thank you.
Thank you. So don't know if anyone had a follow-up comment to that, but there was a comment in the chat, and I think it's more of a query of noting the difference between the state Senate right now and the House of Delegates on the amendment, and particularly the difference between the black caucuses. And I don't know if that has been an issue of conversation elsewhere, or if anyone had a thought about that. Granted, that at this point would probably be pure speculation.
I am, if Bob is still here, I would respond to his point, but it looks like he may have left.
He stepped away for a minute.
Yeah, he stepped away.
Oh, okay, there he is. The point I just wanted to say is that I definitely understand where he's coming from, being trepidatious around the court. And while the Voting Rights Act is something that we're glad still exists at the federal level right now, there's an additional clause in the amendment that says explicitly, standalone, districts shall provide where practicable opportunities for racial and ethnic communities to elect candidates of their choice. And that is just a safeguard that will be in the Virginia state constitution, independent of future rulings on the VRA or the Equal Protections Clause in the 14th Amendment. So I think that's just an important point to highlight how we will be making sure that through our state constitution in Virginia, we are not solely dependent on those federal rulings. We have our own safeguards.
Thank you. All right. Other hands up. Marjorie, did you have another comment?
Yes, I did. I think if our party advocates to defeat this amendment, we're going to be yielding the high ground to the Virginia Republican Party, who I think can then justifiably accuse us of arch hypocrisy. After advocating for reform for more than a decade when we were in the minority, and then rejecting it when we get to the majority, because we seem to be salivating for the opportunity to go back to gerrymandering in our own interests and to draw the maps that we prefer. So I think I cannot oppose this amendment, and if we are going to oppose it, I'd far rather we took no position.
Thanks, Marjorie. And Ankit, you had your hand up as well.
Yeah, I wanted to address the point about the permanence of this amendment that some people have made versus other options. So I think it's important to point out that this amendment is better than the system as it currently stands. So what we're putting in the Constitution here is a better system than currently exists. There's nothing stopping us from then passing for the next round in 2030 an amendment that makes it even better, that makes it fully independent, which I will be, advocating for. I'm sure others on this call will be joining me. We can always do that. We can always go back and say, let's make it fully independent for 2030. But what we can't do is go back and make it fully independent for 2020. This is the opportunity here is to create a better process for this next round of redistricting, which is what this amendment does. And even if we're not able to create a better process for 2030, it still creates this process that is better than the alternative. So I would suggest to you the choice isn't between this amendment and the perfect solution. The choice is between this amendment and the alternative, which is the current system. And for that reason, I think that we have to recognize that this is what we should go for, and then let's fight for something even better for the next round.
Thank you, Ankit. So we have about 8 minutes left. I wanted to give Chris another opportunity to say something as our grassroots activist that helped start off the conversation. So Chris, did you have any kind of final thoughts?
Well, let me address, I think there was a question about why the Black Caucus in the House versus the Senate, why they were different. Was that one of the earlier questions? I wish I was a fly on the wall and I would have loved to have been there. I do know there was a lot of discussion and debate within the House Democratic Caucus, probably every day about this amendment. I do know that 2 of the 4 Democratic delegates from Arlington pledged to me and to others that they would support this bill and vote for it. One even up to 24 hours before the vote was taken on the House floor. I'm not sure what happened in those caucuses, but I think there was a lot of discussion and maybe arm twisting, which led to the fractured caucus vote, unfortunately. But keep in mind that the Senate Black Caucus solidly is behind this, as well as 38 of the 40 senators. So that was almost 100%. Well, I think there was a good conversation here. Keep in mind, I think we do need to put these protections in the Constitution. This would be a fair way to end gerrymandering. We can't just say end gerrymandering and wave a magic wand, it'll happen. Otherwise, we would not be having this discussion. It would have been done before. But I think this is the way that we can get it done. We can protect the interest of everyone in the Commonwealth. The transparency piece, I think, is so important. If they try to pull one over us, we will know what they're doing, and we will call them, on the carpet and make sure that they hear from us. Communities of interest, you can draw your own. We're going to be working with Princeton Gerrymandering Project to try and get groups and communities to draw their community of interest and use this in their testimony during the hearings that are held, saying, this is my community, do not split us apart. It gives us a chance to do that. Without passing this constitutional amendment, it rests in the hands of the General Assembly, and that can be changed depending on the whim of the people who are sitting in those seats. So I think there's a lot of good resources available, so I hope you'll take a look. I'll be happy to answer any other questions. My email is chris7307@gmail.com. So feel free to get in touch if you want.
Thank you, Chris. And thank you everyone for staying on for almost an hour and a half to discuss this really important issue. I think we've had a really strong discussion, and I'm glad we also had people that disagree with the amendment chiming in. I do encourage everyone to come back next week as well, where we're going to be kind of flipping the framing, and our featured grassroots activist will be Craig, who opposes the amendment. But I hope we will continue this conversation because it's an important vote. And as mentioned, there's a lot of resources available. I'm going to put in the chat again the link to the roundtable we had earlier this year, as well as the resource folder. I also encourage everyone to educate themselves generally on gerrymandering issues. And I would say my favorite is that 530 Politics podcast series, because they did a really good job looking nationwide over a couple episodes on the gerrymandering project.
Maggie, the Committee of 100 also did a program on this, and you can access it through their website. It's on YouTube.
I put the wrong link in there. This is another resource that's not the resource folder. The National National Center of State Legislatures has a redistricting resource guide.
And Ballotpedia just has a basic facts. It has the language. It has the changes that would make that would be made in the Constitution because of the amendment, and it spells out all the votes, who vote, not roll calls, but numbers.
All right. With that, thank you all.
Thank
I know
you.
it's a couple minutes early, but again, encourage you to come back to conversation next weekend.
Thank you for herding
Thanks,
the cats.
everyone.
Thank you.
Thank you.
Take care,
Great job.
everybody.
Thanks, y'all. This is really great.
Enjoy the weekend.
Thanks, everyone. Bye.
Thanks, everyone. Have a good weekend.
Thanks, Maggie and Jill.
I'm going to keep the Zoom room open for a few more seconds so people can check the links.
Oh, yeah.
Good job, everyone.
Thank you.
Very well run.
Very fortunate to have really well informed people.
Absolutely.
Thank you all.
That's the Democrats.
All right, I'm going to close the room now. Thank you all.
Bye.